Good afternoon, everyone. Thank you for joining us on today's webinar for Canadian Immigration Compliance, New Immigration Compliance and Enforcement Regime. Today's webinar and training is being presented to you by Larry Linton, Senior Lawyer Immigration at PwC in Toronto, Canada. As we begin today, I want to let everyone know that you will all remain on mute through the duration of the broadcast. The broadcast will be recorded, and if you have any questions, please post them to us using the GoToWebinar tool. We'll answer all questions at the end of the broadcast. The presentation will also be emailed to you this afternoon. Before we get started, I just want to make a brief announcement about INSZOOM's Power User Conference. It's being held in San Ramon on January the 22nd of 2016. We hope that our clients can join us for this exciting day of learning, knowledge sharing, and socializing. Lunch and breakfast are included in the cost of attendance, and if you register by December the 15th, you can save $20. I'll share the registration link with you in today's email when I email out the presentation. Thank you, Larry, for joining us today. We're very excited to learn what you have to share with us.
Thank you, Kristen, and good afternoon, everybody, and welcome to the seminar or webinar today. My name is Larry Linton. I'm a senior immigration lawyer at PwC Law in Toronto, and today's topic is with respect to Canada's immigration compliance regime. What I intend to do in today's seminar is to list the history of where we are and where we have come from with respect to the compliance, talk about the government powers in investigation, and what happens on a finding of non-compliance. Are there any defenses and what the consequences would be? I want to also leave you with a case study that seeks to highlight the new administrative monetary penalties, which is a further enhancement of Canada's compliance review process, and then leaving you with some practice tips to deal with the new regime that we are in. I've been practicing corporate immigration law for over 20 years, and more amendments to the regulations have taken place over the past 5 years than in my first 15 years. The focus in this respect has been the ramp-up of the compliance regime in Canada. In fact, since 2011, the Government of Canada has steadily announced extensive reforms to the Temporary Foreign Worker Program to ensure that qualified Canadians and permanent residents are given first chance at available jobs. In addition, the government has implemented important changes to strengthen the labour market impact process, to impose new and extensive and onerous obligations and conditions on employers, and to enhance and give authorities the power to verify employer compliance through inspections and to impose consequences for non-compliance. A major change came about in 2014 when the Temporary Foreign Worker Program was reorganized into two distinct programs. The Temporary Foreign Worker Program is now referred to those streams under which foreign workers enter Canada at the request of employers following the approval of a labour market impact assessment. This was previously known as a labour market opinion, or LMO. The second stream is the new International Mobility Program, which incorporates all those streams of work permits in which foreign nationals are not subject to an LMIA. Most recently, with effect from December the 1st, further enhancements to the compliance framework have been introduced to better deter and respond to employer non-compliance with conditions. Turning to the actual government investigative powers, there are three main tools. The first two, employer compliance reviews and reviews under ministerial instructions, relate primarily to the labour market impact assessment process. The first, the employer compliance review, happens during an LMI assessment. It is not an inspection. The employer compliance review is an assessment whether a returning employer has provided each temporary foreign worker with wages, occupation, and working conditions in line with those provided in a job offer. If the employer is deemed non-compliant during an ECR, ESDC has the authority to ban the employer directly, has no authority to ban the employer directly, but can issue a negative LMIA. Immigration, on the other hand, will do the banning of the employer when the temporary foreign worker makes an application for a work permit on the basis of the negative LMIA. Reviews under ministerial instructions, or commonly known as roomies, occurs after a positive LMIA has been issued. Employers found non-compliant with any of the conditions following an inspection may also have the existing LMIAs revoked or suspended using these powers. Inspections occur after a work permit has been issued, but it must be triggered, and inspections apply both to the LMIA stream or the LMIA exempt stream of work permits. So it is common to both. The three triggers of an inspection are as follows. First, if and when ESDC receives information to suspect that an employer is not complying or has not complied with any of the conditions imposed, that would trigger the inspection or reason to suspect. An employer who has not complied with conditions as set out and whose name and address have been put in on the banned list may be subject to an inspection based on its known past non-compliance. And finally, and most importantly, there is random selection. We expect that 1 in 4 employers every year are going to be selected randomly for an inspection in order to determine compliance trends. So that is what triggers the inspection. The scope of the inspection covers 21 conditions as described in the immigration regulations, and the look-back period has increased to 6 years. In one of the amendments, the look-back period was 2 years, but that has now been extended to 6 years. And during the inspection, a pending labour market impact assessment request may also be suspended. So going through the inspection and coming to an initial finding of non-compliance would mean that an employer has failed to demonstrate on a balance of probabilities compliance with Canadian immigration laws, regulations, or program requirements. However, a finding of non-compliance may also be made if the employer refuses to provide documentation which has been requested or is otherwise uncooperative during an inspection. The question is, what defences, if any, are there to an initial finding of non-compliance? Well, an initial finding can be justified by providing an acceptable reason that renders the employer compliant. The justification provisions are listed in our regulations and cover everything from a change in federal or provincial law through to errors made by the employer in interpretation made in good faith, or an unintentional accounting or administrative error. And there are also categories that are similar. So this list is not exhaustive. There is one particular extra ability to have your non-compliance justified in similar circumstances to those listed. So at the end of the day, if you have found to have an initial non-compliant employer, there are no justifiable defences, what is the possible consequence and outcome? And here we have a dividing line, because in the pre-December regime, on a finding of non-compliance, an employer could be banned from using the temporary foreign worker program for 2 years, and its name placed on Citizenship and Immigration's website, as well as the website of ESDC, and revocations of LMIAs that are in process by the employer. After December the 1st, we have now the possible imposition of administrative monetary penalties, or AMPs as we call it, up to $100,000 depending on the severity of the violation. And bans can be imposed ranging between 1 to 2 to 5 to 10 years, and in some cases to a permanent ban. The important issue to bear in mind is that it's the date of violation that governs which regime you fall into. It's not the fact that now we're in post-December that any violation is going to result in the imposition of fines and bans. The date of violation is critical, and that is the dividing line, the date of the alleged violation, because if that occurs, even if an inspection is triggered today, obviously today, a few days after the introduction, the violation is always going to be in a pre-December regime, but over the next coming months, the violations would rest in the post-December area, where the consequences listed on that slide would be effective. Now, the AMP, I'd like to spend a bit of time discussing the AMPs, this point system, this method of utilizing this points method to penalize and sanction an employer. The AMPs provide inspectors with a variety of penalty options and are also intended to provide more incentive for employers to take steps to ensure that they are fully compliant with statutory requirements under the 2 streams of temporary foreign worker program. Under the regime, each separate violation will be assessed and assigned a point total by the inspector. The higher the point total, the harsher the penalty. One factor taken into account in this regard is the type of violation. Violations have been classified into 3 types, type A, B, or C, with type C violations being the most serious. There is a matrix and grid system that sets out these various type A, B, or C's violation. Another factor to be considered is the employer's prior non-compliance history, as well as the severity of the violation. This is a factor over which the reviewing officer appears to have a large amount of discretion, because the points assigned are a range. There's a range between 1 and 6, or 0 to 3, etc. If an employer has made an acceptable voluntary disclosure, which is another factor of non-compliance, this could reduce the number of points assessed. The violation of a single statutory condition that involves more than one temporary worker will be treated as a separate violation for each temporary foreign worker. For example, if the employer failed to pay overtime in breach of the applicable employment standards to 6 temporary foreign workers, that would amount to 6 separate violations, each of which could lead to penalties. If a regulatory condition has separate elements, a failure to comply with any of the elements will each be treated as a separate violation. For example, one of the conditions imposed on an employer is that the employer must provide substantially the same wages and working conditions to a temporary foreign worker as was set out in their offer of employment. Reducing the base salary and removing a benefit such as a car allowance will be treated as 2 separate violations under the AMP regime. That is, the failure to provide salary or substantially the same salary, and failure to provide substantially the same working conditions by removing the car allowance. Voluntary disclosure is the new mechanism to reduce the severity of a violation on a potential finding of non-compliance. But the important consideration is that it only applies to a finding of non-compliance by an employer after December the 1st, 2015. Voluntary disclosure does not apply to any potential non-compliance prior to December the 1st. And the voluntary disclosure does not justify non-compliance, but reduces the severity of the violation. So, as I mentioned before, with respect to the defences, the voluntary disclosure is not a defence under the new regime. All it seeks to do is reduce the penalty and the points. But it's important to remember that the voluntary disclosure must be done before an inspection is triggered. If it's done after, then there's no benefit to the 4-point credit which you would be entitled to. So there is some strategy that goes around whether or not to come forward and voluntarily disclose a non-compliance. There is some, thought process and some methodology that must go into that decision. So having said all of that about the new AMPs, I wanted to leave you with a case study. And the facts are stated on the slide. Essentially what has happened here is that during the inspection, an interview was conducted and one foreign national complained of continued verbal threats and has not been paid the wage that was promised in the employment contract. The employer has been requested to provide documents related to its policies, and all requested documents have been provided without delay, and there are no previous findings of non-compliance. So ultimately, the employer has been found not to have provided a workplace free of abuse, and that the pay and working conditions of the foreign national is not substantially the same. So having looked at the case study, what we are dealing with here on the left-hand side are the number of violations. We have identified 3. We've also classified the violations into one of the 3 kinds. We've got 2 Bs and 1 C. The first violation is the first history of the violation. But as soon as you move down to the other 2, you then add up the other 2 violations. And all of this is added up with the severity score as well. So for those 3 violations, anything between $35,000 and no ban can result in an increase to $100,000 and a 10-year ban. So this is very serious stuff. The ability to penalize, sanction, and punish an employer who has not confirmed or has paid an employer less than they promised to pay, changes the working conditions, etc. Now, my commentary on this is that in my opinion, the severity of the AMPs and other sanctions that appear under the new compliance regime appear to be far higher than those imposed by other federal regulators in Canada and other jurisdictions. For example, under the Canada Pension Plan, a maximum fine of $10,000 may be levied per violation. The Canada Border Services Agency may levy a maximum penalty of $25,000 per contravention under the Customs Act. Environment Canada may levy a maximum fine to companies of also $25,000 per environmental violation. Further abroad, in the US, a non-compliant employer may be fined up to $16,000 per worker under the guest worker program. Further afield in Australia, the maximum employer fines include $15,000 for corporate infringement. A new government was elected recently on a mandate to liberalise and reverse some of the more restrictive immigration policies implemented by the previous government. Announcements so far have been well received. Some of these examples include the lifting of the visa requirement for Mexican citizens that was implemented around 2009, the resetting of the age of dependency back to 22 from 19, and reversing the new Citizenship Act, which has imposed stricter eligibility criteria. But unfortunately, nothing yet has been said of the temporary foreign worker program. The monetary penalties have just been implemented, and I think it's just a matter of time, hopefully, before the government winds its way down to Service Canada, ESDC, and Citizenship and Immigration Canada to review this compliance regime, particularly in light of the fact that it seems to be out of step with a lot of its own compliance regimes for other agencies in Canada. So for now, the question is, what can you do in this new compliance world? And that leads me to the next topic, which are our suggested practice tips. The first is to be proactive. In our opinion, the compliance doesn't start at the inspection stage. By then it's too late. The compliance starts with the application for the LMIA or the LMIA exempt work permit. So be proactive. Keep records. Ensure that personnel records are comprehensive, transparent, and readily accessible. And we suggest that the immigration compliance folder, essentially, be kept separate from any of the employment documentation, like a disciplinary report or performance reviews, etc., etc. You also must ensure that accurate terms and conditions of employment are recorded and that are complied with. For example, work hours. If the work hour per week is 37.5, make sure that that is on the application form and that carries through to the annex, and ensure that the worker is working that amount of time per week. If the work schedule is different, if it's a compressed work week, make sure that that is reflected in the application for the work permit and is documented, and that the worker is working those amount of hours. You have to comply with the annex. Under a labour market impact assessment, the annex sets out the strict terms and conditions regarding the employment, and it's important that there be compliance with those conditions, as well as the attestations on the application form. Too often in the hurly-burly world that we live in with applications being filed, there are the same 21 conditions listed on an application form. And we insist that the employer reads through each and every one of those, because a tick mark indicates that you have read and will comply and abide with that condition. And if you don't, you may be subject to an inspection and one of these penalties. Lastly, I think it's important that you consider performing a self-audit to test your own threshold compliance and to discuss those findings and develop a voluntary disclosure mechanism, because as I said, that may lead to a point reduction in any finding of non-compliance. So in conclusion, in today's climate of compliance, inspections and enforcement, you must be ready. And it's no longer a question of knock knock, who's there? It's more like we're here, knock knock. That concludes my seminar, and I'd be happy to take your questions. Thank you.
Great. Thank you very much, Larry. Let's have a look and see here. It seems that everybody really understood your training and they don't have any questions. So this was fantastic. Thank you very, very much. Excellent training today. And thank you, everybody, for joining us. We really appreciate your time and your attendance. We will be sending out this presentation to you shortly, and we wish you an excellent afternoon and a great week. Thank you.
Thank you.